Good afternoon, everyone. I'm Tom Fitton. I'm president of Judicial Watch. Judicial Watch is a conservative, nonpartisan educational foundation dedicated to promoting transparency, accountability, integrity in government politics and the law. Through our educational endeavors, we seek to high standards of ethics and morality in our nation's public life, and we seek to ensure that the political and judicial officials obey the law and do not abuse the powers entrusted to them by the American people. We obviously don't endorse, maybe it's not obvious, but we don't endorse candidates for public office, so we certainly don't oppose them as well. Our topic this afternoon, which has already expanded over the last few days, is the question, is Hillary Clinton constitutionally ineligible to be Secretary of State? My remarks will be brief because I think our panelists here are far more expert than me on the subject. But from our perspective, according to the Ineligibility Clause of the United States Constitution, no member of Congress can be appointed to an office that has benefited from a salary increase during the time that that senator or representative served in Congress. A January 2008 executive order signed by President Bush during Hillary Clinton's current Senate term increased the salary for Secretary of State, thereby rendering Senator Clinton ineligible for the position. Specifically, Article 1, Section 6, Clause 2 of the U.S. Constitution provides, no senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time. The provision is seen by most as designed by our founding fathers to protect against corruption. There's interesting history to this clause, but former President Richard Nixon famously, or infamously, circumvented this constitutional provision after appointing former Ohio Senator William Saxby to the position of Attorney General. The Nixon administration managed to force legislation through Congress to reduce the salary for the position of Attorney General to the level that existed prior to Senator Saxby's appointment. This scheme, known thereafter as the Saxby Fix, was also used to allow Senator Lloyd Bentsen to assume the position of Treasury Secretary under President Clinton. And I should add that was done with the help of President George H.W. Bush. Though President Reagan reportedly did not appoint Senator Orrin Hatch to the Supreme Court because of this provision. In response to our announced concerns about Clinton's ineligibility, a Saxby fix to reduce the salary of Secretary of State to previous levels was passed as a joint resolution by Congress on December 10th. Not one member of Congress seems to have stood for the Constitution and opposed this end run. I think it was all passed by voice vote, which means that I don't think there was a recorded vote one way or another.
I think there was one member on the floor at the time, and the whole session lasted 2 minutes.
Yeah, that's even more reassuring. Thanks, Ilya. President Bush is also expected, if he hasn't already, to give his approval to the so-called fix. But in our view, this effort cannot change the fact that the salary has been increased while Senator Clinton served in Congress. Simply put, the Constitution does not provide for a legislative remedy for the ineligibility clause. Barack Obama should select someone who is eligible for the position of Secretary of State and save the country from a constitutional battle over Hillary Clinton's confirmation. No public official who has taken the oath to support and defend the Constitution should support this appointment. We're considering a legal challenge to the Clinton appointment and have similar concerns about the announced selection of Senator Salazar to be Secretary of Interior. I had some concerns about Ray LaHood that have been put to rest, but supposedly House members generally don't run into the problem that senators do with the ineligibility clause. But as Judicial Watch considers its next steps, I think it's important to really flesh out the history here and the origins of the clause, the specifics of the various fixes, and why they may or may not be constitutionally suspect. And to that end, our panelists have really been instrumental in educating the public about the ineligibility clause. I think it was Ilya Shapiro and a post over at Cato that may have gotten the ball rolling in the blogosphere about it. And Ilya is a senior...
that credit goes to Eugene Volokh.
Volokh got it first?
By a day,
okay.
Yeah.
Well, all the great minds were thinking around the same time about the issue. And Mr. Shapiro is a senior fellow in constitutional studies at the Cato Institute, and editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was Special Assistant Advisor to the multinational force Iraq on rule of law issues, and he's practiced law at Patton Boggs and Cleary Gottlieb. He's also an adjunct professor at the George Washington University Law School and lectures regularly on behalf of the Federalist Society, the Fund for the American Studies, and other educational and professional groups. Before entering private practice, he clerked for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit, having previously obtained his law degree from the University of Chicago. We're also pleased to be joined by John O'Connor, who's a partner in the Washington office of Steptoe & Johnson, where he's a part of the litigation department. Mr. O'Connor focuses principally on civil litigation matters, in which he's represented clients in cases involving allegations of fraud, civil conspiracy, legal malpractice, unfair lending practices, and unfair competition, as well as in cases involving application of RICO and the Alien Tort Claims Act. And I guess you're going to be very busy over the next few months, given what's happening in the news these days, plus with the financial markets and some of the corruption scandals. But most importantly, Mr. O'Connor is a writer, and he's written a number of articles for legal publications in various areas of legal interest. And he had served as a judge advocate in the United States Marine Corps, where he was involved in over 200 court-martial proceedings, I presume, and he obtained his law degree from the University of Maryland School of Law. And he's authored what many consider the most authoritative treatment of our subject, which is the emolument. The law review article is entitled "The Emoluments Clause, an Anti-Federalist Intruder in a Federalist Constitution," and that was published way back in 1995. And I'm sure, John, little did you know.
Little did I know.
That you'd be talking about it with respect to Hillary Clinton being appointed Secretary of State in a future administration. But here we are, and I try to lay it out without giving away the store, but there's a lot to be said here, and I turn it over to you.